Good morning. Good morning. Oh, hey, Liam. Hey, maybe kind of early for us, isn't it? Yeah. Well, we're getting ready to set up for Sarah Moon's motion hearing. It's good to see you. I am getting the feed ready, and I also have a few things about battered spouse syndrome. As I said yesterday, there was a good question in the chat on exactly what that means in Florida and what's all the hubbub about. So I thought we would go over that before the trial starts. Or not the trial, but actually the hearing. Sorry about that. Don't get too excited. It's not what I mean. Okay. Well, the first thing I want to put into the chat is this 28-page analysis in breakdown of battered women syndrome, setting a standard in Florida. And it's quite long, but mostly I'll be going to page 14 in it to go over some particulars. But for those of you that actually want to know a lot more about this, that is a more in-depth analysis on how we got to where we are in the state of Florida with this particular defense and how it actually plays out in the court, what cases are most prominent in it, and what those cases actually mean in regards to case law on how this actual statute gets used. But let's just start with just like a definition, okay? Um, the 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 minimalist definition of battered spouse syndrome is that it's a legal defense using battered spouse syndrome, in that it can argue that the systematic abuse suffered by the victim of this syndrome of domestic violence has led them to believe that killing the abuser is the only way to avoid being killed themselves, and that it relies on self defense or an imperfect self defense with it. Okay. In the state of Florida, you need to, if you're going to use this defense, as we heard in previous hearings, is you needed to file 30 days ahead of the trial date to notify the state and the court that you're going to use this defense. There are some other particulars in regards to the defense. Okay. Um, here is, whoops. Mm, here, I think I've got it. Here is the wiki on it, which is just gives a basic United States breakdown of the start of it, the symptoms. And some of the symptoms that they'll say are violence, depression, passivity, the lack of social support. When in a abusive situation, actually leads predominantly to this syndrome. But it's related to intimate partner violence, which there's been a lot more studies on, a lot more information available over um, the last 10 to 15 years, especially in moving through the court systems. It's been mentioned more often than not. And so this actually use of this syndrome as a statute in many areas has become more prominent. But we're going to concentrate mostly on Florida. Okay. In looking at articles, in law journals in regards to battered spouse syndrome, they also are indicating that it refers to a state of mind that may exculpate women who have been the subject of abuse by a husband or partner. This is geared mostly, even when this statute was written, it was written in the female voice of woman, always being the one who has this. In other states, they use a much more broad term and just like spouse in general. um, these are one of my pet peeves in the way we do legislation in the United States, are so mm, so sexist centric. It just drives me crazy. As if any other partner could not also be battered and have this syndrome. Yeah, come on. But anyway, they do indicate that it is the abuse by a husband or a partner, um, and that they ultimately retaliate. The retaliation, however, is understood in this syndrome in the context of a cycle of abuse, that the woman is defending herself from continual abuse. Now, that word continual is key. Okay. Many times in self-defense arguments, there's must be a showing that there was a threat or force or imminent danger of bodily harm to a person or persons in the general area. That in the mind of the courts, it seems justifiable under this defense, especially where the violence is occurring in someone's home. So therefore, the castle doctrine provides that people, are permitted to defend themselves in their home, and they don't have to retreat in the case that there is a threat of violence at the home. In other words, stand your ground. But that doesn't work if you live together, correct? Under the statute. So, battered spouse syndrome statutes have been created to help with this situation. In that case, when you are actually in domicile, cohabitating with the abuser, um, they in all the situations, these the victim and the abuser actually reside in the same home, making that the castle, and the stand your ground uh, statutes less effective, like as I'm indicating, because you actually live together. Um, Especially if you're married, some of that coverage for those actually dissipates also. So this statute was used to also legally deal with that issue. The concept of a battered spouse syndrome provides justification where, in most cases, a woman or spouse is subject to, like I said, the continual physical, emotional, and mental abuse over a long period of time, and that creates a cycle of abuse. And this cycle provides that the abuse gets worse and worse over time. Uh, there is an event where the spouse is physically injured, and then the abuser apologizes or compensates, and with significant amount of attention and love, or forgiveness, bring the victim back into a relationship, and it happens over and over again. All right. For in the use of this syndrome in Florida, to be able to be utilized in court, the burden of the proof is on the criminal defendant. Um, and they have to show that that the defendant was just subject to a cycle of abuse at the hands of a heinous, of a spouse or domestic partner. No, this it can be difficult to show if the abuse was emotional or mentally traumatic, rather than often the physical effects that are much easier to prove in court with medical records and such. There's also the timing issue that must be considered. For example, like self-defense types of affirmative defense, they must be shown to defend her life from bodily harm or injury. In the case of battered woman syndrome, where fear is ever present, it's going to be harder to distinguish at what point the violence was imminent, or whether there was any physical threat or force of violence. The point of battered woman syndrome is to state that this person was not thinking as clearly as a rational person, and may have seen threat where someone else may not have, or based on the conditions they were living on with the domestic partner. Okay. Um, it's still going to be up to the defense to show. The difficulty in these cases, where the spouse is the abuser, sometimes some of these cases has been when the retaliation happens when the abuser is actually asleep or incapacitated in some way, as in the case with Sarah Boone, with being inside a suitcase. Either way, battered spouse syndrome has been used in Florida, but the parameters of how well it works and under what situations it is most appropriate are still in question and go back legally back and forth, which is one of the reasons this case is going to be so enticing in regards to how matters of law in this situation get settled, which is why we're here today for the hearing about the state objecting for them even trying to use this defense, stating that Sarah Boone does not qualify for this defense and that she can't use any evidence against George as far as abuse until she takes the stand and actually proves that she was a battered spouse. Yeah. So it brings us here to today. And let me just give you a copy of this article also. Hello, Anna. All of that was for you. Above is a link to the actual good review of the statute in Florida, actually. Um, about 28 pages worth of it. Just just about how we use it here in Florida. All right. Let me see if I can get the. Hmm, I can get our feed up. Let's see which one are we going to use today. Let's see, there's that one. There are two feeds today that I do believe we're going to. So one of them's got to be great, right? Both Law and Crime and Trial TV both seem to be live today with the feed, and both look really clear. I'm going to try to start with the smaller channel. There we go. And let's see if that is, yeah, that's better. Well, they're not live yet, so we'll go back to just me until they come off actually. Um, but yeah, hopefully that little review of battered spouse. Now I'm not a lawyer, you know that. I'm just looking it up the same as you would, But I thought it was very interesting. It's a really good question, Anna, yesterday. Just to get us all, on the same page as to where we're going to be heading into this hearing this way. Hopefully, I'm not roboting. I just got a yellow signal. I really hate when that happens. I'm going to close some things. And hopefully, it comes back a little bit now. I'm going to have to close that. Oh, it looks like it might be coming a little bit better. Let's see. Um, how's this sound? Can you guys tell me? Yeah, I don't want to be roboting. I really hate when all of that. Oh, now it does say that it looks like it might be getting a little bit better. Can someone in the chat tell me what the sound like? Oh, it does sound good, Anna. Oh, good. Sometimes I worry. Thank you. Oh, a little bit of robot and he's gone. Yeah, it's dipping. Like when it dips like that, I think it gets robot-y. And I just don't want the feed to come through, robot-y at all. Um, I'm looking for the law and crime. Listen, there's someone was in an elevator with our salty ADA Will J, And they said, "Oh, how long is it going to take for the expected for the motions hearing today?" And Will J say, "As long as it takes." He stared deep into the depth of his eyes. Like, I'm telling you, the prosecution has had it. They have had it with the shenanigans. They're ready to go. Oh man, this is going to be, quite the back and forth. And I'm hoping that it's all going to be live for us. I really do. It should, right? Yeah. hmm you wouldn't even have clocked the robot. That's how minute it was. Yes. And that's one of those words, minute, that you can say it either way. It means something different both ways. And it drives me crazy because, like, it looks exactly the same. Minute or minute. Yeah. Hey, Liam. Thank you. Mm. Oh, boy. So, hey, Beck. I'm sorry I didn't shout when you first came in. I was busy reading about battered spouse. I almost didn't see you. Like, welcome and good morning. It's a good one. Just sitting here killing time waiting for a feed to go live. Now, this court is supposed to start in 8 minutes. And these live feeds, they always wait until the last 60 seconds to start up, just to make a bear sweat. So I'm going to sit up here, talk, ramble, nonsensical to you for like 7 minutes while I get progressively more nervous waiting for the feed to go live. Because without it, we got nothing. Just me. Yeah. And I would really rather see it. Mm. Yeah, Sarah Boone is definitely. Yeah, she's very worried about her clothes and her shoes and about getting her snacks. And it's all about Sarah. She keeps forgetting that somebody actually has passed away here. A little bit of respect would be nice. Welcome after dark. Good morning. Good morning. Yeah. I'm very excited for this trial. And all the hearings get me excited. I know some of you were disappointed yesterday that it was just going to be a hearing, but considering it's going to be on the key factor of how the defense is going to proceed, I think this is quite exciting. A lot of times everything happens before we even get to trial. How many times have we gone through motion and status hearings and you know, uh, motions to suppress, anti-slap, trying to get stuff straight and getting evidence tossed out. All of these pretrial hearings that go on before that actually get a lot of things resolved before we even walk into a classroom. I mean, the courtroom. Ooh, what a misspeak. Yesterday I called jail church or court church, and today I'm calling it a classroom. Sometimes that's what it feels like to me because I'm learning, every day a little bit more about some law in some state or some way of doing things, you know, state to state, even sometimes country to country. Lawyers doing law stuff. Exactly. Exactly. Yeah. I do like it. I really like having a bunch of you here that kind of like it too. I don't feel so alone out here. you know, Knowing that you guys are looking all this stuff up too and interested in some of the same things I am about these cases. I find some angles of them very fascinating. And just intriguing, and I got to follow it all the way through. And with this one, it is the line of defense, and now it is anyway because of Sarah Boone actually just changing her tune. Although I don't think Sarah's the one who changed her tune. I just think she found somebody to hear her, because I actually think this is, and I've said this before, that the use of this defense was the linchpin to the separation in all the other attorneys who just did not want to do it because they saw the risks of it. For all of us, we've been saying, many of you have said the same thing as I, that it just doesn't make any sense that you can go from accident to then self defense. And never before talked about him being hit and beat. And I guess they're just trying now to deal with all the extra injuries that the medical examiner and autopsy report are going to convey to the jury the condition that George was found in. Uh, doesn't exactly match the hide and seek, innocent play story that Sarah had been selling all along. There's so many interesting videos out there from psychiatrists and body analysis, you know, channels and true crime channels, investigative channels, and everyone focuses on those interviews, in regards to Sarah and her demeanor and how she changed her mind and how she was so convincing that George was in a good place and she was his person and she always took care of him and she knew him better than anyone else. Yeah. But wouldn't take any responsibility that that suitcase in her game may have led Tuesday, which obviously it did. So I wonder if she's going to get her snacks approved. I can't believe the defense is wasting so much time on the fact of what does Sarah actually get. You know, yeah, analyzing her different smirks. Did you see the one I picked for you today, Liam, on that thumbnail? My goodness. Like, does she look full of herself? And I do think she looked better in the dark outfit than she did in that one yesterday. Man, she looked older in and even very heavy, much heavier dressed the way she was yesterday. She looked a bit handsome, the day before in the dark navy shirt and in the dark pants. Did they do a psychological evaluation for Battered syndrome? Yes, they did. It is required, actually. She had to sit not only for Julie Harper, who she's been seeing on and off since 2021, because she was originally hired by Maurice Paudet. Mm, you know who I mean. I don't know why his last name just stuck in my throat, but yeah, Padilla. You know, Mauricio Padilla, her defense attorney, who did most of the work on this case. He was looking for battered spouse, but he did not register it 30 minutes before. I mean, 30 days before. And he actually asked to be removed from the case 2 weeks prior to the trial. Uh, the first time we got the continuance. Yeah. So they did have to do a psychological evaluation both for the defense and for the state. The state has another expert witness, a forensic psychologist, that did their own interview with her that happened in the beginning of October or the end of September, and then she was deposed. And that is where the statement came to light in one of the motions in limine that we read recently within the last couple of weeks about Sarah Boone actually hitting George with the bat out of his hands. He was like trying to maneuver through the zipper there that she says he could wiggle his fingers, and how she hit him with that bat, like smacked his hands back. Um, uh, Quite interesting that that has come to light now for us. You know, it, it's a little confusing for me. I don't remember hearing about the bat before, although I know it was taken into evidence from the scene at the beginning, and that there had been rumors that the state did allude, based on the injuries, that a bat may have been used somehow in an attack, and that Sarah may have done a lot more to George than she's alluding to. And I think we're going to hear more about that. I think there's going to be lots that we hear about in the testimony. I'm going to open and just check. It's 9:30 and this other feed has not gone live. And neither has Law and Crime yet. Um, I'm just gonna check this one again. Just make sure. Yeah, because this trial was supposed to start right at 9:30. Mm. And hmm. They're sorting everything out, but I don't see anyone going live yet. So we'll just wait. I'll pull it up as soon as I hear or see anything in regards to any of it. Uh, and you know that, like, well, we'll just talk in between for now. For now, right? Um, and just checking the Twitter feeds also to make sure that people aren't posting in regards to a delay or anything like that. We've got people in the courtroom. We've got Notorious Jules, who's over from the group over there with Trial Live TV. She's often on their channel. And then there's also Kathy Russo, who's the managing editor over there at Law and Crime, and she's also posting on it. You know, um, neither one being a lawyer, but definitely very very interested. Um, yeah. I'm trying to see. Um, at 8 o'clock, Jules already made it through security, and she was able to go up to the 12th floor courtroom. For this last minute hearing, motion hearing. Let me just see if I can pull up Miss Russo now. You see, Miss Roson actually, and she is stating that they're going to be covering it live. It's still on for 9:30. Um, and that there will be jury selection on the afternoon, but that will not be live streamed. And we kind of all knew about that. Hey, Jean, good morning. Good gropes to you. Oh, you're standing outside in the cold? You be careful with those hands. It's cold. It's chilly. I don't know about you, but it's chilly here on the East Coast this morning. And I am not used to being up this early. Like, they just need to get on. Like, at least, come on, put the feet up in the courtroom and let us stare at like nobody doing nothing. But, at least let's get the feet up. Let me know it works. That's what I want. I want to know that everything is working. But it does not look like anybody's up yet. This is the worst part uh, about live hearings and trials. Is the feeds. I really like it when the court itself puts out the feed, and I can go to the judge's YouTube page. I mean, judges with YouTube pages are my heroes. I'm serious. They're such teasers. I know, Liam. They're torturing me here. They're torturing me. I know. Such teasers. Like, where is our true? Like, I'm just nervous because last time it never happened. Remember? Like, we got nothing. And then, like, Court TV had little bits of it later, and it was like so annoying. Like, they better not do that to us today. Yeah, they just better get on it. It's like, give me a feed. I will say that both are the same. Both the feeds I'm going to use are the same. They're just in waiting mode. Yeah. So it just doesn't seem to be much going in on the Twitter feeds either. To tell you the truth, let me just see. Let's go look at Jules again. You can see. Oh, so see, Jules is saying that Court TV's in there. Judge, they're just watching other proceedings in the courtroom. There's a little bit of delay. Sarah Boone has not been brought in yet. The Judge Kraynick is actually sentencing some other prisoners right now who took some plea deals. This often happens where one thing's before the other, Mm, this is. Yeah, Jean, I get you. I'm gonna abuse you, but I'll let you zip me into this suitcase. Yeah, I'm not seeing it. I don't think many do see it. Jean, I think many people would agree with you. At least what I'm hearing. Like my DMs are full of people with like, can you believe the audacity of this? Like how is and it and also several people with very good questions and concerns on what this is going to do for the statute of battered spouse syndrome itself and how it gets used in Florida. Every case builds pro and con towards the use of these statutes and in crafting the changes of law in how things get used. Exactly. Couch, right? Like the nerve of me. I expected a court stream to start on time. Is this my first day? I know you think I'd have a clue by now, right? But I came on early, like I said, and I talked about the battered spouse syndrome and even posted some links for you all above that want to get into it a little bit more. But yeah. Mm. 54, Jen, that's not too cold. That's good. Yeah. Mm. It is good to see you here, though. Mm. Hope you had a good day, Couch. Hey, I checked out a video on the Flat Earthers app, and I don't blame you for being for that to be wild and a little bit like scary. I was just like, what? Like, can this really be going on? And well, apparently so. Hmm. Quite interesting, actually. Hmm. I'm just refreshing. I just feel like my fingers are getting a workout here with all the refreshing that I'm doing. All this button clicking. What if I disappear? You'll know what happened. I just hit the wrong button. Mm. It does feel like my first day couch every time I do one of these. I feel like it's my first day, as I just don't know what to expect. I really don't. Let's check my spacing. Mm, yep. Nope, there. Still not up. Man, what a face that is, huh? Do you remember that day? Pro Say Day? Mm. Oh, 60 sounds so nice there, Anna. It is actually 48 here. I am a bit chilled. I'm in the house, of course. It's not 48 degrees, but it's a bit chilly out there today. It's a crisp fall day on the East Coast. Well, so what y'all have for breakfast? I mean, like, I guess we're gonna have to do idle small chat, like, unless you have any questions about the case or that I could possibly look up or answer for you. But like, this is the waiting is the hardest part. Oh, Juju, that's even colder than me. I know summer is long gone, Juju. 41 is cold. Like I thought 48 was bad, but 41, like, a couple more degrees, you got snow. What is it? Snow at like 36 or so? I don't know. Was it 32 or 36? Anyway, like, are we doing nasty winter, Big? Don't say that. Like, I don't want a nasty winter. I'm like cold all the time. I don't like that. I don't like it. Oh, 28 at night, Anna. Oy, that is like double blanket weather. Double blanket weather indeed. Mm. That's it, Big. Give me some hot coffee. Small talk. Let me check my notes. Okay, funny guy. Hey, couch. I see you. I see you. Y'all know I'm a sucker for cornball humor, don't you? Yeah. Yeah. Oh my gosh. But thanks for that. Yeah, I do need more coffee. You're right, Beck. Like more coffee in the chat, everybody. Cause now it's 9:41. They are more than 10 minutes late. They have gone past my everything's fine waiting. Okay, like they're past it now. They're 11 minutes. 10 minutes was all I could give them reasonably. Now they're working on my nerves. And I'm refreshing both the feeds, and both the feeds are still in the waiting mode. Um, I'm assuming nobody else has a different feed. Not that I could pull too many of them up anyway. Like it would get bad, you know. Let's see if they got anything else to say. You know, the only thing that I see is, like I said, Notorious Jules had said that they were doing a sentencing. And of course, they're not going to uh, put out a feed on the other parts that they don't have the permissions for. This is just for this, you know. But I was fascinated yesterday in that little clip that we got from Law and Crime to when Sarah was putting on her shoes, like her interactions with everyone. She's just a little star there. She's got her stacks of paper and she's been so studious taking notes during the jury selection process. And mm, it's just, I don't know. I just can't imagine what the rest of this trial's going to be like, but I want to see. I want to get there. Right, Juju? I'm like, I'm ready. Like, why can't we start like now? Mm. Did you see that ludicrous display last night? The thing about Arsenal is though they always try to walk it in. Mm. No, I'm not sure, but I did not. I mean, I was watched the video, not the live video, but something else about it. Yeah, Beck, you left the Southwest where it was nice and warm all the time for a nice cold winter. Yeah, yeah. Mm. So like, so the you're saying, Beck, that the worst winters are cyclic. Like it's every 3 years we have like a really really bad one. Like, is that like mainly for the Northwest, or was that everywhere? Well, I'm not looking forward to it. I don't really like winter. I like fall and I like spring. I'm not even a real summer person because I don't like the extremes. But I hear you, Juju. The warm weather, like the warm weather where your bones get warmed, just being outside is nice. Very nice. Oh, Diddy. I would say one word, Diddy. That ought to do it. Okay, that's the East Coast. Like there's like New York. Okay. Yeah. Ow. No words. Well, we got a lot of people here waiting with us. There's a lot of eyes right now, and we're just waiting for the stream to go active. And then you all know the drill here. I'll be quiet while we let the legal system do all the talking for us. It's now quarter of. Like, I hope he gets this sentencing. I would imagine we're going to start closer to 10, you know. And I do hope this is not a trend for court in the trial. I miss George Newman. Didn't he start on time a lot in, his lovely little stretch sessions? I do say though, I am very fond of George Kraynick in his no nonsense, highly legalized way of doing things. Man, he loves his case law, and he definitely has so much patience. Wow, he's been dealing with this since January and keeping it on track. Mm. Good morning, Karen. Good to see you. Mm. Hope you've got some good coffee going. You know. I hope you all do. Mm. That was a joke from the IT crowd, basically a cheat sheet for talking to soccer fans. Thank you very much for explaining, Couch, because you know I didn't get it. Like, nope, 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 not at all. Hey, Maye, good morning, sir. How are you? Mm. We're all just sitting around waiting for something to happen. Hmm. This is our life right now. This is the worst part of this part. I am not a very patient person. In Rocket Couch already called me out for like it being my first day, like expecting things to go on time. Like they never do. They never do. Mm. Mm. We've been talking about the weather and hot coffee. Mm. And I didn't eat any breakfast. I should have. Like I think maybe I'd be more patient right now. Well, I doubt it. I don't think there's a breakfast in the world that could turn me into a patient bear. What? Time to refresh. It's been a minute. Refresh feed number one. And feed number one is still coming up in a holding pattern. And refresh feed number two, which is also still coming up in a holding pattern. Yep, we're in a holding pattern. Yeah, waiting on the court. We are waiting on the court. Let's see. Let's see if there's anything new on Twitter. Nope. But they are saying that Judge Kraynick looks a little different in person. I wonder how different. Like, hmm. So, part of the delay is that, Judge Kraynick had to hear a different case before he starts with Sarah Boone. And they're in a different courtroom. Remember, they've got 50, they had 54, and I heard they dwindled it down to 21, but they still can't fit all the jurors into the courtroom at one time for voir dire, actually, this afternoon. And so they have gone to a different courtroom. And that could be part of the delay. I'm not sure. But they knew about it ahead of time, so I don't think so. I just think it's because they're doing this sentencing prior. Oh yeah, you were confused by me talking in your car. That's true. Me and your car. We've had a thing for a while, Juju. I didn't mean for you to find out this way. But I'm glad you know now. Yeah, I'm just getting silly because I'm really, not doing well with these patience things. Good morning, tomorrow, kiddo. Hey, nice to see you. All over there in Futureland. Mm-hmm. Mm-hmm. It is. How long has this trial been going on for now? The trial itself hasn't even started. We're still in the jury selection process. This is going to be a motion hearing because too many motions were piling up. And I think it's because they're going back and forth about battered spouse syndrome for motion eliminate from the state. And also, Owens is putting all this stuff out about snacks and Sarah getting a shower and poor inconvenience Sarah. She's in prison. And like it's like what an inconvenience to her. Like it's been going on for 4 years. Mm. But they are stating that opening statement should be Thursday. I'm hoping if they finish Water this afternoon, which I really doubt. I will be scheduled for a stream for tomorrow morning, but it may not go off until the afternoon. Um, because they do have to finish the jury selection. He has to sit six jurors, and Judge Kraynick is requesting eight alternates. And his reasoning is because this trial is expected to be 3 weeks long, and he doesn't want anything else to delay anything. at all. He wants enough backup jurors with a 3 week trial that if they all left, he could fill their shoes, you know. You just, no, that's no problem at all, Vic. I'm happy to catch you up. If you want to know more details about the case, there's a playlist in the description for all the coverage we've done all the way back when we started this wild ride with Sarah Boone. What I will say, I wasn't actually speaking publicly on it when she first got charged. You know, it wasn't until it started getting really interesting with all the lawyers leaving and the letters and shit. Like, eee. I was like, what? Like, who writes to the judge? Oh, Sarah Boone does. You know, donuts. Mm, I want donuts. That sounds like a good idea. Mm. I'm glad that Thursday's going to exist. Tomorrow, kiddo's here to tell us that definitely tomorrow's going to happen. And I like that. I like that. Mm. Well, what part of tomorrow will be streaming with, I don't know. But, jury selection's not going to be viewed either way. We're not going to be any covering with that. I don't think I would anyway, because I do. I got a predictably there that like I don't like to infringe on that process at all. I think that process is sacred. I think that jurors need to be protected, their identity, so they shouldn't have to worry about the cases that they try or being held or tied to them in any way before, during, or after. Same thing with witnesses in the case. I do know that we need to know who we're talking to on a witness stand. I get that. Um, but the harassment that happens in, let me just say this: the harassment that is becoming more and more common, unacceptable in some areas, is just absolutely blows my mind. I am actually enjoying the coverage of quite a few YouTubers are getting held to task for this kind of behavior in the true crime community, and that the book is being thrown at them as it should. I'm all behind it because, come on, people, boundaries, be reasonable. You don't go in after people's family. You don't go insinuating that you're going to solve the mystery and start blaming people left and right. There's things like defamation and libel and intentional cause of harm to another's reputation that you can be held for. And I am actually glad to see that some of them are, you know, yeah, because it was getting absolutely crazy. Mm. Yeah, tomorrow, kiddo, you and I've been watching it. It's crazy, right? Yeah. Oh, a custard filled donut. Now you got me going, Karen. That actually, the thought of that is, wow, that's making my mouth water. And it's making my finger gonna go and actually refresh both the streams again, double check, because that's what we do while we're killing time here. Yeah, we try to stay neutral, don't we? Mm, I do my best, but I have to tell you, I get like kind of involved in my head about the guilt and the evidence and everything, but you'll never find me knocking on the door of anybody. So getting too involved in people's personal lives and everything in regards to this. Um I think I'll just keep my distance and do my commentary, you know, draw some lines there in the sand on what I will and will not do. Often YouTubers show autopsies of children, which was horrible for the family after the fact. Stuff that wasn't even shown during the trial because the judge didn't think it should be public viewing in deference to the family and those that loved the child. And we've called that stuff out too. I mean, people sometimes just don't think, you know. Oh, and I remember that one trying to use the defense of, oh, it was behind a paywall, so it's okay. It's like, no, it's not. Like, no, who cares that they had to pay to see it? You still put it out there publicly, something that the court didn't even want out there publicly. Like, yeah, in deference to the family. You should have been more respectful. Yeah. Behind that paywall, it doesn't matter. You know. Mm, not OG House of Donuts, but donuts just the same. Hey, listen, at this point, gin or any donut would be great since I can't get out of the house. Like somebody bring me a donut. Mm. Oh man, it's they do sound so good. Uh-oh, Juju says there's a man in a scooter behind her and he honked at her. Today is going to be a good day. Scooter meeps. Okay, so was it really a honk, Juju, or was it a meep? Like, inquiring minds want to know. Curious bears absolutely need to know. Is it a meep? Or was it a beep? Or was it a honk? I mean, these are all different things when it comes to motor vehicles. Like, and what kind of scooter? Like, we need details. You can't just come in here and say scooter and leave. Hold her to task, chat. Like, make her give us the details. Yeah. You found a scooter emoji. Look at you. Jeez, I gotta change some of the emojis for the channel. I gotta add some things. We need the Nopio. We need the scooter. Oh, it was a meep meep. Also, it was a traditional scooter then. Like, yeah. Well, not exactly throaty. Hello, Jester. Yeah, that's right, Jester. They don't honk, do they? No, they don't even beep. That's how come we came up with the meep meep. Like, that's what a scooter does. Like, at least in my mind and Juju's mind and anybody who watches us silly show on Sundays. It's pretty funny. Mm, okay. What is Judge doing now? Yeah, I think he's still doing his sentencing. He's so patient. I should really be patient, for him. Like, absolutely. He's worth the wait, isn't he, Judge Kraynick? Ah. Mm, nope. Nope. Don't see anything new yet. It's a cute little light blue Vespa. Ooh. That does sound cute. I know you prefer white, green pinstripes. I always picture you in candy pink, though. I don't know. It just goes with the meep. It's just how my brain works. Hmm. Nope. Nope. Nothing. 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 This is so frustrating. Geese honk more than scooters. They sure do rocket couch and like with more oomph. Like, hey, nothing bad against the scooter, but it definitely doesn't beep or honk. It's definitely a meep. It's like a little thing, you know. Oh, here we go. Refreshing the feeds again. And it is 10 o'clock. We're officially 30 minutes into a hearing that we can't see. Hmm. Let me see. The other chairs, like they're not really saying anything. Um, okay, just a few minutes ago, the last notification says they are hearing other cases before Sarah's, and that's why there is a delay. Everybody just be patient. As soon as the feed comes up, they're going to bring it in. Oh, huh. There's another account saying that only Court TV will be streaming it, and they're not set up until tomorrow, and that's why we don't have a feed. I don't think that's true, because I know that there's two other channels advertising that they are in the court. Like now. Like Law and Crime is saying they're there now, and so is Trial TV Live. I hate when that hearsay stuff. Like, just start a panic. Like, wait to stop up there's hard. Like, why would you put a rumor like that out like that? It's crazy. Don't do that, especially when we're waiting. Judge Kraynick is actually watching you. Judge him right now, so be nice. You know what? If George Kraynick is watching me, I just want to tell him how amazing I think he is. How he has more patience than I've ever seen on any person walking this planet, and that, well, he's got a really, really tough job, and I think he's been handling it admirably. And his actual love of the law is evident. And I do wish more judges were like him, holding people to case law, or not people. Let's just call them right out. The attorneys in the cases to case law, to actually represent the best that they can in regards to whatever motions they are making, or whatever they are putting out there for the judge to review. Like, you need to give your judge something to sink his teeth into. Like, if you leave it up to him, he may not be exactly happy. It's up to you to prove your case, and case law does it. And I love this judge for it. Hey, Charlotte, good morning. Oh, thank you, Beck, for letting me run. I appreciate it. That's, every little view counts, every little interaction counts. As I'm learning to stay in the algorithm. Mm. But I do love our judge. Mm. If we had to deal with the actual retiring of Judge Newman, so that we no longer got stretches, and all of that, at least we have another very patient in judge that, you know that we can, let's look up to. Up, I have a visual of a clock. Oh, I'm gonna switch feeds because I think I'm going to use this feed with law. We're gonna check this feed here with law and crime, and hopefully, uh, whoop! Look, we have a clock. That rumor in regards to All right, the volume's all the way up. Sarah's coming in. Here we go. Mm-hmm. I don't hear anything yet, though. Okay. Oh, she looks much better and not in seafoam green. This white with the suit, it looks much better. Look how much thinner she looks than yesterday. That blouse was yesterday. Okay, this is a smart look here. Not so bad. No, she's smiling too much. She's just loving all of this. It's like she's not even on trial for murder. Hmm. Oh, you got 10 minutes to watch with us there, couch. Mm. Oh, which one? I put the wrong one up. I want to be round. Can I be round? There we go. You guys didn't tell me I got all squared out on you like a nerd. Oh, see. Oh, wow. Cranes, huh? You guys have interesting conversations in the chat when I'm not paying attention. Listen, a Chanel suit is not gonna help this be. No, Charlotte, it's not. Like, and I can't, like, I realize she has to like exist. But her enjoying all of this attention really gets under my skin. It really does. Uh yes, calibrate your expectations, Sparrow Kiddo. Don't, like, she's gonna drive us crazy, but we'll all be here to support each other. I know. Yes, we will. Yeah, and it's very businesslike, isn't it? Like yesterday was quite frumpy with that seafoam green blouse was not good. But I actually think she looked best in the dark navy that was kind of like, the detectives wear that from the stand. Chelsea Knappel, or when during the hearing, um, and then the next, Sarah had the next day the same like dark kind of shirt, looked very similar in look. But I actually thought she looked best in that one. She looked thinner, healthier. Mm. I mean, not that she's that heavy or anything, but and I'm sure she's actually devastated she doesn't get to wear makeup or have her hair done. But oh well. Mm. Yes, she patted him in a reassuring way. Watching her interactions with the attorneys is just drives me crazy. Is it just me, or does it seem to anyone else like she's trying to dress like a lawyer? Yeah, and for her to say that she didn't know anything about law except for that she was actually looking up law and helping George with his court case well before she was arrested. And from the time she hit the jail, she was using the library and asking them to bring case law to her. Like, yeah, she ain't so slick. Like she forgets that everything you do in the prison system is documented. Everything. And it's for public consumption. That's why she's always complaining that we know what she eats for breakfast. Because now she doesn't even eat breakfast anymore. You know? Yep. Those interactions remind me of how Casey Anthony was with her. Like, oh gosh, yes, overly friendly. Like, because if you think about it, this is the most important relationship she has right now in her life. It's the closest thing to an actual friend or life saving thing that she has. That these are the lawyers, and they have to kind of be paid to be there, but not in Sarah's case. Actress wannabe. Well, maybe I do think that she treats this like this is her show. But it is her life. And she may be spending the rest of it in prison. Since she didn't take that 15-year deal. No. The minimal sentence, if she's found guilty, is more than 22 years. It's 22 and a half years. Minimal. There's aggravating situation here. The use of this defense, the use of the bat, the reckless disregard when she sat on the couch and taunted. She didn't just ignore him, she taunted him. Oh, I think she believes she's innocent. I think she believes that whatever happened was justified. The use of this defense says almost is so demeaning to the victim, to George, even though they were in a contentious relationship, and you should not abuse another in any way or form. Okay, but still, well, the use of this defense just kind of discredits him completely and makes it like he deserved it. He had it coming because of how he treated her. Well, there's plenty of documentation of how she treated him also. I don't think innocent is a word we could apply here, although in the court of law she's innocent until proven guilty. Yep, 15, Charlotte. That's what she would have got. And she walked away from that deal because she really thinks she's going to win. Apparently, she hasn't looked into the history of her attorneys. Okay, why don't we hear anything? What is going on? Don't you think we should hear something by now? Hold on, let me check the other feed. All right, now I'm nervous. I'm going to check the other feed. The other feed has no sound either. All right, I guess we wait. Let's hope they bring it on. Does she think she caused George's death? Well, during the one interrogation, she is told that she did, and she says, "I realized that she was her not letting him out is the reason he's dead." And did you see them just bring her 2 glasses of water? Her and her water. Oh my God, stay hydrated. Oh, I hear sound.
William J. for the state.
James Owens on behalf of Sarah Boone.
Here we go.
Tony Henderson on behalf of Sarah Boone.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th. And then the party's objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Oh, who is speaking for the state? It looks like it would be Will J. Where's that cacciatore? Oh, that's cacciatore. Yeah. What's it? His clerk is very busy. There's a lot to go over. There was a lot of back and forth. All those motions between the defense and the state in regards to this issue. And this is very important in how they'll proceed with what evidence we will get to see and presented in the trial and how the defense is going to proceed. I do believe that's Will J. He's been so salty.
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Kopsel and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes in as 1 for the purposes of this hearing.
Responses to what was pre-marked as A.
No objection.
All right, what was pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as state 3 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as state C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire. That was not the purpose of our motion. I don't think we mentioned voir dire because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now preliminarily is, if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony was is, we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is, we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, again, she is saying that she did not have malintent at that time. When he starts to say, I cannot breathe, now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we are asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence, or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
Good morning, Judge.
Morning, sir.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what I'm what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask, I'll have a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told and outside sources too. They are able to make a determination based on their training and experience. So,
but based on the Akendo case, which is cited by the state as to what what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense. Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone, or what question position. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made, or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, could I respond?
Briefly.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act, based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yes.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres' hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records is relied upon in Roberts v. State by the 6th DCA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
My concern is open. Can it be mentioned in?
Yes, that's your decision. That is your decision. If you want to mention an opening, there's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state, not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law. Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Not from the state. She's allowed to be here to watch. I understand, but I want to know whether she's going to testify. I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir. I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
The problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases, cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found, do you need the site?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
The state stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about
No. The words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion where Supreme Court is giving instructions to the court with those comments. For them not to put that in there, I disagree with.
Okay, well, the Jackson case speaks for itself and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that in this expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from two incidents, one in 2017 and one in 2018. The third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I have not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. Mm-hmm. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe were incriminating to her.
Understood. But respectfully, that's not the issue before the
I
court right
understand
now.
that. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, Jorge Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have Jorge Torres' medical records prior to me sending them to you? All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on Jorge Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since we have some level of common ground here?
My case is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure
Judge,
there I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a 0.31 BAC. Every
In
time,
2018?
2008.
I'm talking about the 2018 incident with regard to the plate
I
glass
have to look at
window.
the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find based on that whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be, some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what I know. You may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that. When it was filed, what was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else.
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing up everybody in like sardines?
Response.
I don't know the layout of 23, so
Can you all approach just for a second?
Okay, so yeah, Charlotte, you're right. Like above everything else that's going on today about like the defense not being able to represent their case, we don't know what Sarah Boone's going to testify to, or whether any evidence for battered spouse syndrome is going to be allowed, because it's all going to hinge on what she has to say. And we don't know of the 550 records what's going to come in, because not even the defense knows what they're going to use yet. There, a week before trial. But I digress. And now we've got COVID testing. We've got positives. We've got a crowded courtroom. We've got concerns about people breathing on people. And wow, this is the case to follow. This is definitely the case to follow this year. This is going to be the case of 2024. I thought Murdaugh had it all. I really did. But yeah, the Alex Murdaugh case has got nothing on this chick. Nothing. I mean, and it's not even her. It's everything around this case, okay? Not just Sarah herself being such a character, but I mean, the defense attorney and the DA are already sniping at each other. This is pretrial. This is pretrial. Owen cannot contain himself, and the ADA Will J is salty. You know, and plus we've got all of the complications of the actual law surrounding battered spouse syndrome, and what you can and cannot do on it, and how it tries not to be overreaching to actually the victim, the murder victim in this case, allowing all the freelance parameters of it, as far as the mental state that Sarah might have been in, can be quite prejudicial to the victim. And so some of these things that they've added to the law are to try to balance it out, but it just makes it just a sticky wicket to try to get around, so to speak. I agree. It's just crazy, bonkers.
All right, court's
Wow.
going to take a 15-minute recess to address jury selection location this afternoon, and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, well, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense?
Hello, defense. Wake up. Did you not get your Snickers?
Correct. That is correct. I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you.
Okay. So he mutes for the 15 minutes. They're going to come back. And from what I understand, and what you heard too, correct me like if I go wrong, but can you hear me? It says mic. The judge has muted the mic there. Hopefully you can hear me. Okay. But from what I understand, when they come back, the defense is supposed to provide the actual list of evidence that the objections are going back and forth for, because it hasn't been, each different motion has put it out of order. So the judge doesn't know what they're talking about. The state doesn't know what they're talking about. And the judge, before actually going to weigh in on what's going to be, to hear the arguments, he needs to know exactly what pieces of evidence they're talking to. I have to say the defense is not making a very good presentation today. It does seem that there's quite a bit hinged on Sarah's testimony, and they just want to move along with as if everything's going to be fine, and seem to be quite testy about having to provide the overt act. It was like pulling teeth. But basically, Sarah did give testimony to the expert witness in regards to hitting Jorge with a bat on those fingers, that him poking those fingers out of the suitcase set her off. And that is what they're claiming is the overt act. Now, why it took 3 motions in 4 weeks for them to actually say that, and why they wouldn't just say that, like, I have no idea why they're holding everything so close to the vest. I think it's because they don't actually want contrary evidence to come in about it. I am sure there's plenty of the fact that he was actually confined, and Sarah going along like so happy that his fingers could get out of the case, actually using that as self-defense and as reasonable cause as to why she wouldn't be concerned about him being in any danger when she went up to bed that night. Her testimony at the sheriff's office was that she just went to bed because, like, he was in the suitcase, and she knows that she left enough space that he could wiggle his fingers through and open it and get out if he wanted to. And she had no concern. But now that her story has changed about hitting him with the bat and all of that, and after listening to the actual interview with the neighbor about the really loud noise going down the stairs, I wonder, was George already dead when she went to bed? Hmm. And when did she hit him? Before the videos or after? No, hmm. Her story just keeps changing. But the only one we're going to get to go by is the one she gives the jury. And it won't matter everything else we've heard. The only thing that's going to matter is what comes into the court. And that's what this wrestling is about today. This wrestling between our snarky, salty ADA Will J, I'm getting very fond of, but he's like really losing his patience. And Mr. Owens, James Owens, who also is pushing back with like, just leave me alone. I'm doing the best I can here. Like, don't ask me to actually lawyer. Like, come on. Like, this is a pro bono case. Like, I'm here for the public relations. You don't actually expect me to work, do you? I mean, Sarah's running the show. He's so testy. I do predict there will be an Owen eruption in the middle of this trial. Like, he cannot contain himself. He just looks like the hissy fit type to me. There's a lot of whinging going on. He gonna lose his cool. Yeah. Hmm. Very possible he was demised. Otherwise, with BSS, I doubt she would have gone to bed. Exactly, Anna, because that's the other thing that bothers me about using this defense. She says she had no concerns and she went to sleep and everything was just fine. But then, on the contrary, that would be the opposite if she has actually battered spouse syndrome. She would be on edge and worried and feeling under imminent threat. That's the whole linchpin of it. It puts you in such a state that you're expecting the worst at all times, and you feel like you're going to be killed. And that's what it's meant for. Okay, it's meant for like, why, if your spouse is sleeping, would you feel like you were going to die? Well, that's what this defense is about. The prior acts, the 15 times he beat me, the coming home from work, the constant abuse, the mental this, the mental that. I snapped. I did it. That's the defense. But in this case, they have to lay the foundation for it, and they're having some difficulty. And here's the difficulty: we've all heard it. All of the third party testimony puts Sarah in control of the relationship. Sarah manipulated when he could use the phone. Sarah was his great support system, got him out of jail, worked the legal system, did everything they could. Sarah out there saying how good he's doing. You know, listen, Sarah was the one in control. We've got her ex husband's testimony that when she drinks, she gets violent. And he himself has never struck her, but he has had to restrain her multiple times from being violent on him, that she gets physical and violent. We've got police reports that also say the same. We have arrests of George every single time Sarah calls in retaliation. She feels threatened or he hit her or kicked her. Okay, there are several reports where George got arrested and Sarah went and was, before they even took him away, had changed her mind and was screaming that she'd be right there to bail him out. You know, there's also the police report where she was listed as the aggressor, that they believed George's story that he was just trying to get away from her and that he had kicked her and she called the police. You know, if George had access to the phone, I wonder how many times Sarah would have been the one that got arrested that he had called on her. I mean, these are the things I think of. And I'm just looking at everything, but I'm not sure what's going to come into the jury now. Yep, typical, right, Anna? I mean, it's very, very typical of that state of mind. But what I'm not seeing is their ability to prove it with Sarah because of the control. Walking on eggshells. Yeah, uh, I I actually read a snippet of that. Someone sent me just some part of it. Sarah requested 5 peppermints, 2 juice packs, 2 bags of chips, a bag of candy, and either a Pop Tart or a bag of cookies. Yes, that was requested yesterday by Owens in open court, petitioning the court to allow her commissary so that she could be energized and stay awake, because she gets 2 a.m. in the morning and they don't let her back to her cell till 9:30 and she's exhausted. Like, this is rough on Sarah, being tried for murder. Such an inconvenience. I mean, they separated her from her 30 slices of cheese. I mean, who's minding her cheese? She must be under extreme stress. And it could be, Charlotte. There is the issue of that also. But it could go either way. Like, I really try to stay on the line here. Like, I don't want to blame a victim. I do believe that they had a contentious relationship and that they both hurt each other. Um, but I don't believe that, like, she's did not contribute just as physically and mentally to the abuse in this relationship. So it's difficult for me. Because like, nobody should get mentally or physically abused in any way on any part. I don't think George was innocent either. Um, I just don't think there's a lot of third party collaboration for Sarah's claims. And basically, you cannot just walk in with just her claims. That would make it her word against his. And because of her actions, or allegedly because of her actions, he is not here for his voice to be heard. Exactly, a cycle of violence, and yeah, case after case. I see it over and over again, and I've read a lot on it actually, and I hear you. She could be a victim, a 100% victim, and actually be able to use this defense, but legally they have to prove the particulars, and that's going to be the problem. Not only because some of them are not corroborated by third parties or any other third issue besides Sarah's own words, and I mean anything besides Sarah's own words. Okay, anything outside the scope of that, they cannot use only her words to prove it. Okay, the actual expert witness isn't even allowed to testify based only on Sarah's words. Sarah's testimony will provide the evidence that can be collaborated. Okay, that will allow an evidence to come in to collaborate the actual statement. If there is in Sarah's story a way to prove the overt act, that's it. That's what's going to happen. So, well, do you see how interesting this is? Like, and I'm so proud of everybody being able to talk about this on opposite sides of it, having different opinions, and everybody being respectful and just like absorbing the other's opinions and just going back and forth. And that's how it should be. And I really support that, and I'm very pleased to see that that's what's happening, because we do have people that with work with domestic abuse victims, and it's really hard. You see what they go through and you're more familiar with their state of mind and all. But then there's also the legal side of it, to where the legal system is not caught up completely with that defense. I think Anna would agree with me that it does fail on the part of the victim in some issues. And I think that failure comes in part with them trying to balance it out for the deceased, who is no longer there to defend themselves. You know what I mean? So, yeah. Usually medical records, arrest, and psychological treatment on the yes, exactly. If they can define the overt act, that will all come in and show the cycle of violence and show the state of mind that Sarah could have been in, and give credibility to the defense. I agree, Anna, totally. But it's the problem with the law is the overt act has to be stated first and proven. Yeah. Jester says, I think the lawyer wants all 47 pages in because he has no clue what she's going to say on the stand. I think he's worried that she will go off. It's um, definitely, definitely something that they should be concerned about. I do think that there's great risk of her doing that. I don't know if they can depend on exactly her following the rules in any way. Sarah's going to do what Sarah's going to do, right? That's just that is just how Sarah is. Mm. I'm playing with earbuds. Sorry, guys, if you hear some rustling around. I'm trying to get one in that's not all low battery. Okay, there's that. All right. Yep. So she is definitely an odd duck. I agree with you like that. But that doesn't mean that she wasn't battered. I mean, I actually think she was. I think it was with both of them, you know. Um what's going on here? Oh boy. Mm. Sorry about that, guys. It's still not bad. There's hopefully they will be soon. What? I'm just going through and looking at some more of the comments. Honestly, definitely an odd duck. Definitely, everybody talks a lot about how weird, and some of the reactions that Sarah Boone has and the craziness, the writing of the letters and all. Like, she's really given everybody a lot to talk about. But in the end, all of this is allegedly, and we need to have a fair trial. And we have to wait and see what those actually get presented. And based on this hearing, like, we still have no idea what's going to be presented as actual evidence in the trial. What's going to be allowed to come in. Hmm. Yeah, I think the judge made a good decision in regards to allowing them to explore Sarah's testimony. They don't have to disclose word for word what she's going to say. There's no rule that says that. And it does look like the judge is going to limit it to exactly to her actually being able to present the overt act and talk about what happened that day. And if she actually says to the jury that she hit him with the bat and with the fingers, and to open with that, with her testimony, is going to be quite interesting. Because remember, there's going to be nothing on the defenses before that. And if it does not actually qualify as the overt act, according to the judge, nothing else is going to come in, and that's where the jury is going to be left after the state presented its whole case. Remember, the state goes first. The state is going to play all of those tapes, everything she said. The state is going to be able to present all of her words before she takes the stand and says the opposite. This is what's so intriguing to me about this case. Like, how is that going to play? What is the jury going to think about that? I know how upsetting it was for me to all of a sudden, out of the blue, hear a different story from her again. I'm like, what? Like, I've never heard that. Like, what's going on here? Hmm. Yeah, I want to hear what the psychologist has to say. But if they don't prove the overt act, we're not going to hear what the psychologist has to say, at all. Yeah. I do feel for them, as unpredictable as she is in trying to figure out how to narrow down the documents before they hear what she actually says. Exactly. Yeah, Juju, I'm thinking the jury's not going to be too impressed with it either. Especially the amount of interviews and all that they have, and the amount of statements that they have. Hmm. What occurred to me last night? I'm wondering if her history in general at the jail, or even, with her other attorneys, is going to come in. I think it's very prejudicial and not probative at all, and would definitely not make it in. And I'm sure they're screening for it in voir dire. Like, I wouldn't want people to know about it. you know, Ju- Juju, I could see that. She says, let me just put this up. Okay, I believe by the end of this trial, the jury will be quite offended by the defense. I could see that happening because Like, I'm actually quite offended by the defense. His actual lack of decorum and respect for the process is really annoying to me. And I get that with a lot of attorneys, like, that are disrespectful for the judge or whinging and whining about having to do their job or just actually expecting other people to do their jobs for them, which is kind of what Owens is doing, like dumping 550 pages on the state, knowing they're going to complain about it, knowing they're going to go through it and whittle it down to exactly what the issue is, and present it to him in a nice bow so he can go to the judge. Oh, yeah, like just those 47 pages. Like, did you guys get that? Like, I actually saw that, like, that's just like doing his job for him, And the judge actually saying, I'm not going to do your job for you. Like, you tell me out of those 47 pages, what is the inference? We already reduced it from 550 to 47. Could you not, like, be bothered to read the 47 pages and tell us what you're up to here? Like, I could hear the snark that Judge Kraynick, if he wasn't as patient as he was, would be exuding from him because, man, I would be so annoyed. I would. I would. Half of this trial is going to be showing prior inconsistent statements. Exactly. It's going to be impeachment of Sarah Boone herself in her testimony. Exactly. The defense feels like an immature lawyer, as if it's his first day in court, except for look at all the experience he supposedly has. He brought his whole high school team to play with him, too. Mr. Henderson has a long history with Mr. Owens, one that I was really not too pleased to uncover some of the stuff that they had been up to, but apparently they've been friends since high school. And this guy out of Arizona, like, I don't know how he fits in back, but he's been mentioned before too. He's on Zoom, by the way, out of Arizona. I don't know what he's doing, you know. And also Berkeley, the ex medical examiner they wanted to bring in as the criminal, the crime scene recreator. It looks like Judge is coming up. Here we go.
You ready? We're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Kester on behalf of the state. William J. for the state.
Defense. Ms. Boone is still seated at counsel's table wearing the same gray suit and white blouse from this morning. Can you all approach?
Okay, what was that? They're muted. They're muted again. Okay, I don't know. Like, Ruh-roh, I don't know what that was. Did anybody catch that? Yeah. Yeah, that's just the thing, Anna. She seems to be very happy with it. I think that she gets stroked a lot by this defense attorney. He's always like pleading her case. She doesn't get enough sleep. She needs snacks. Like, can't she wear real shoes? Come on. Like, I think she's getting the attention she so rightly was complaining she didn't have in all those letters. Nobody's paying attention to me. Bench conference off the record. Yes, but about what? What was the issue? Did he just, like, I thought he just said, can we approach the bench? That's it. Like, I need to hear. Ay, ay, ay. I did hear some tension in the state when it came to talking about COVID and wanting to be in a larger area, not be confined. I think there's some concern about this, about COVID with people testing positive that had been in the jury room. Mm. Oh, tomorrow, kiddo. You get some good sleep then. Thank you for joining us this morning. I appreciate it. I know it was late for you. Did you see the eyeballs on Sarah? She wants to know what they're saying. I think he is going to give them a time frame. I don't think that the defense is ready. I think that's what he's saying to the judge, that he doesn't have the list that he said he would get, like he's unprepared. And I think this judge is getting a little annoyed with this. I don't really think it's a good idea to piss off your judge before you go into trial. And I know he wants to handle all these objections prior to getting to trial. He wants a smooth trial. He wants everything to go through. He doesn't want 80 million little sidebars in private conferences based on issues that should be handled before we get to trial. This judge is very pragmatic on that. He's trying to keep things on track. I have such respect for him. This man is so patient. So patient. Well, this is not the first time the defense has come in to completely unprepared to argue anything in regards to their own motions or to support their documentation. I recall in another hearing where the judge literally said to him, "You have until the end of the day, and I need to see case law," and he still didn't file it, and he still didn't put case law. To where the judge is like, you need to tell me what to look at and how you're proving it. We have to remember that judges are lawyers. They know how it's done. They know you're able to do it and capable of doing it and should be doing it. Don't argue with the judge. Okay? Like, don't argue with the judge. If he says that's the way it should be, like, that's the way it should be. Watch for steam coming from out of his roll. I mean, it might be. If this guy is not ready with this list, I would imagine he's going to have. He could just actually throw it all out. He could just agree with the. He could just say, in that case, if you're not prepared to argue your side of it with the actual list, then I'm going with whatever the state says, because they at least tried to be prepared and do it. It could go that way. That would be very unfortunate for them. Well, it could definitely go that way.
All right, court's going to step out for 1 second, and then you can email that exhibit list to Madam Clerk, and then we can go from there. Thank you.
Oh, he didn't have it. He didn't. And the judge is, he's going to go air out his robes, Charla. I think you called it. Like, he's hot. Like, the court is going to step out for a moment to get a breath of fresh air because the defense is not prepared. Again. That's not going well today. Not going. Man, how long does it take? Like, does he have somebody back at the office? I mean, I'm wondering if he has anybody else working for him. This man who couldn't even pay his dues to represent Sarah one time. That was a lovely little fiasco. I know, right, Anna? And we're back. We're back at the seal, the great seal of the state of Florida. Oh my gosh. I just cannot with this. I cannot. Like, I'm laughing now, but like, if it's going to be 3 weeks of this, I can imagine we're all going to lose our patience. Like, and we'll probably be getting some reports of Sarah screaming at Mr. Owens again. There was already an incident at the jail in the weekly reports about their voices being raised and a bit of commotion coming from their visitation room. Well, Mr. Owen actually apologized to the guards at that point and took blame for the whole thing, saying that it wouldn't happen again. But I can imagine that she's going to be getting a bit testy with him if this continues, if they continue to keep annoying the judge. I think Sarah's even smart enough to know that this is not good to get on the bad side of a judge right before your trial or during your trial. I mean, it's kind of obvious, you know. Call the legal secretary, have them send it. That's my point. point, I wonder if he even has a legal secretary. He's got no like paralegal doing his like case law or helping him with his briefs. You know, he seems to be really tired and overworked from all his interactions with Sarah. And like, I get it. She's probably exhausting. But like, you'll have this whole team. Who's doing what? Why is nobody doing the paperwork? And why are you so disorganized? You got all these people. Like, you know? I don't know. I do remember two women sitting at the desk with Sarah, and when he needed a proof of certification or filing, like nobody offered to help him. He wasn't able to get anybody at the office, and the judge was really like, "What is going on here? Like this is like lawyering 101. You don't file anything without a certification of the filing." And so, like, where, like, how come there's no date? Like, why can't you give me the date? You did file this, right? Like, you know. It was really rather embarrassing. A couple of YouTube channels had done some parodies on it, calling the imaginary person, Martha. Like Martha, can you help me out? Like with this, Martha, you know. Mm. That really loud noise was a message on my cell phone. I forgot to turn the volume off on it. I apologize. Well, they still. I wonder how long that they're going to need for this now. Well, let's just look at some more. She's certainly learning slowly. Why did you say that name? What name? Sarah? Oh, the name Martha? That was a name they made up, like the parody channel. Oh, they made up the name Martha as a secretary. Is that the name you mean? Yeah, it was like they were making up that the imaginary secretary in Owens's office was named Martha. And she's like a 90-year-old woman who can't use a computer. Like, or something like that. It was pretty funny. They had some memes and all about it, I saw. Yeah. Yeah, it's a meme, right? Yeah, I saw it. Like, yeah, they were just tossing that around. Like that's the person that works in Owen's office. Like Martha, get me the date, Martha. And Martha can't tech, obviously. Yeah, that's what I'm referring to, Jester. That meme. You got it. Like, yeah. You know, we thought this was going to be a quick hearing this morning, but it does appear that like we're going to be here for a while. This doesn't bode well for us actually having opening statements tomorrow, does it? Like they're going to finish for there this afternoon? I don't think so. Looks like we might be Thursday afternoon, or if I know this judge very well, he'll say Friday morning. Well, I'm going to create the stream anyway, and hopefully we're going to get back on the trial. And Juju, don't be too upset with me. I have no control over this. I know you want this trial to start as bad as I do. Oh, yours was a meme? Batman versus Superman. Both names are Martha and Kent. Asks Wing to protect this. Oh, okay. It could be coming from the adjuster. I don't know, but I just know I saw the meme. It was an older white-haired lady, and her name was Martha. And yeah, she was the secretary that can't take. But I get it. I get it. Like, oh, this is oh, I see people moving around. I wonder, like, come on, George. Like, stop giving him too much time. This judge is so patient. Like, I can't believe that the defense is pushing him to this limit. I'm not convinced either, Juju. I don't want to break anybody's heart, but they're just yanking us around, aren't they? Like, yeah. They are. I'm not convinced it's going to start this week either. If it's going to be again on Monday, you know? We're supposed to have opening statements in the Adam Favale trial tomorrow. Uh, that we're going to find their last jury member today. Remember, Joe Kraynick wants 6 for murder, second degree murder charges in Florida only need a jury of 6. And this judge wants 8 alternates because, like, he's thinking COVID, he's thinking, like, a long trial. He doesn't want anything disrupted. He wants enough alternates to fill in and then some. All right. Like, he could replace the jury, the whole jury, and then still have spares. So he's thinking ahead. And he's doing it a little different by, getting a jury pool to select from, a pre-approved section, and then going through voir dire with all 53 of them. Yeah, everybody was exposed. Charlotte, I agree. The people that tested positive were there the day before. They have one person who was worried about it, but they keep testing negative, but they could still turn up positive tomorrow. It's going to be a problem. Yeah, definitely. I do think that this judge is going to start penalizing the defense sooner or later. As a matter of fact, if this list doesn't come through, we may see the first one today where he actually just tosses the whole thing out and goes with the state based on the defense not being prepared or able to bring any counter argument. I think that I agree with Charlotte. Sanctions are rare. They are like a last thing or an unavoidable thing, and they're usually done after anyway. Um, it's not like unless there's something really vile that happens, like we've seen in some other cases where, contempt of court is threatened, like right there and then, for an egregious act. There's some movement. I think we're coming back. Oh, he's here.
All right, we're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State, you can get appearances.
William J. for the state.
Defense. All right, thank you. Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's 5th amended reciprocal discovery exhibit list. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision of defendant's 5th amendment exhibit list was e-filed on October 3rd.
Why can't we hear him? Get near your mic, dude.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir. Okay, go ahead.
And Judge, this was a little bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there.
What?
And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So
What?
I don't know
What?
when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense.
I'm
And
going to have to mute.
So I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay.
Response?
Wow, just wow. Take a deep breath, ADA Will J, please. Hey, Shill. Okay. All right. Does he seem a little hot
It's
on
going
the
to be
collar?
considered a separate hearing for the record. So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing. So I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve out. What it has is what, and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline. Count up as 80 photographs and videos.
He is prepared.
Attachments and rebuttal.
No,
Count up as
there.
147
Mr. Owens.
photographs and videos. There is metadata that comes with all those files. So there is a date stamp and timestamp on each of those files. For instance, 12/25/2019, 1:10 p.m.
AKA, I'm
Another
sorry
one
to think
might
that
be
you don't know how to
10/26
text, but it's not my problem.
6:06 p.m.
Sorry, not
They all have
sorry.
file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will received without objection as states 4.
So just to give the court an example,
The prosecution will now demonstrate how an average person can pull up a timestamp on a video. Ouch.
on page 49 of 59 of the PDF labeled case in chief, entry 31107 in this PDF from the phone extraction is labeled videos. 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is
Metadata.
the case in chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020. Culminates in a text from the owner of the phone saying, "And bless you and all of you too. I'll get capitals rid of him." So that's the context of those. Which is our
Whoa.
case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages.
Yeah, December, Charlotte.
It starts, and it basically
That shows
involves with
premeditation.
conversations with or about the decedent,
How does premeditation
conversations with
work
his
with
family,
this?
which I anticipate the defendant is going to testify she was terrified of, and there was problems with all the time. It's going to give some context to those things.
This is a legal rodeo.
Mentions when they
Like,
became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of that child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos
So they're
were
going to
pertinent
use the
within these timeframes.
habits
We did our best to narrow
of
it down
Sarah
to
Boone
what
herself
timeframes
to
we
prove
said.
that nothing was
We
going
believe
on.
we'll give a
Ay,
good rebuttal
ay, ay.
picture after she testifies
Talk
about
about
his
well
family and her
prepared.
relationship with him. So that's where we're at. So as far as like the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are
Nope, they want to just get rid of it all because
objectionable
it's
for any particular reason.
damning to the
We believe
Sarah.
that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81
Didn't
minutes.
Sarah say it was her phone that would
If there's an
prove that
authenticity issue,
George abused her, that she had
because
photos on
one of
there,
their
and they're not
objections
finding
was
the photos.
relevancy, foundation, unknown origin date, hearsay, and Crawford issues.
Unknown origin,
submitting to the
Sarah's
court,
phone,
if I can
date,
approach the court.
metadata, relevancy, Sarah's habits in general,
Southern Third, 598 from the Second District.
Sarah's own documentation on what was going on the day of the incident, February 23rd.
Lamb versus State,
Hmm.
46 Southern Third, 400 from the Fourth District Court.
I can't believe that the defense actually took that podium and said, "We don't know when this video was taken."
Jail,
And we can't figure out how to figure it out.
Southern Third, 656, Fourth District Court of Appeal case 12 in 2007.
It is not even the trial date yet.
A very low bar for authenticity. as Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact.
It
And
is.
with this digital
I agree,
evidence, it can
Charla.
be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to
Chain of
unlock it
custody.
and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Ms. Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women.
Really?
But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up
Yes.
to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense.
And she said
Then
that in
the
December.
rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone can be inferred from texts,
Charla, thank you
and
so
how the
much.
relationship was with the family and who may or may not have been the psychological aggressor. As far as
Appreciate that.
hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the confrontation clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision, was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay and is not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. Or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. I can't respond to you, I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every entry from this phone extraction.
Yeah, that was a
that
nonsense
corroborates
claim.
with the images, most of the images, some were from unallocated
Sorry, you
space.
can't take their defense for not an
corroborates
excuse.
the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics. And then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you.
Exactly.
Response.
I'm sorry, Judge, but I still don't know when the video was taken.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So
It's
without
relevant
knowing
to the
how it's
lack
relevant
of
and
other
what their
evidence of
theory is of it
abuse.
being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity? That these are just boilerplate objections
Yeah,
to all photographs, all video.
that's right. Stay on
Yes,
topic.
well, they're not to all photographs and all videos. There are things that we
It
list.
is an objection to all cell phone photo evidence the state intends to introduce. It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent
It's not his job to do your job for you.
objection would be. I don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case.
Oh my
How can I
God.
do that? If they show you a picture, like a picture of artwork,
Judge, I've been practicing for 25
all
years
right,
and I just
don't
don't remember
know
this
how that's
lesson from
relevant
lawyering
to this
101.
case, or a conversation that takes place between
can't
two
help
other
it.
people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation to get it in? It's putting the cart before the horse.
No, it's
That
not. You should
pertains
be
to the rebuttal
objecting to the
evidence.
December message
What about
about
the
it
evidence
being
that was
like
outlined and
more
that the state intends
prejudicial
on
than
using in its
positive,
case in chief?
or
That's-
too far a
that's
time
it,
in the
Judge.
distance
How
that
How do I know they
relevant.
are
Or
going
that
to be
she
able to
was
lay
talking
the
about
proper
something else.
foundation for that evidence?
Dude.
How do I know? That's the thing well, I think the procedure goes like this.
I hear
Yeah,
you,
I
Turtle.
could be wrong,
Objection.
but I don't
That
think
makes
so.
my
The procedure goes like this. The
defendant
state
look
has a
bad.
piece of
My
evidence.
client is
They
looking bad
have
here.
identified to someone, all right? They get it marked as an exhibit.
Exactly,
Okay,
Charlotte.
at
It's
a
not about the
certain
pics
point in
that were there.
time,
It's
the
about the
state
pics that
asks
weren't
if we
there.
can
The ones
introduce,
she
we'd like
said
to
were there.
introduce
That weren't.
exhibit number 1 into evidence.
Exactly. Impeachable.
Defense, either
Testimony.
objection or no objection at that
They're
time.
avoiding
I've
the
heard the
point.
witness who've identified it. I know what it is that time, and I have some relationship to it at that time to make the proper objection. Just
Please
getting a
don't
picture
educate the judge
now,
on the
and I'm supposed to
procedure.
say,
He knows how it's supposed to go. Dude.
no objection. I don't know what they're using it for.
To impeach
Guess what, Judge?
your
The
client.
videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it.
And-
But when
and
you
to create
have
the timestamp,
animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
correct.
Sounds
keep
like it
using
covers
those
the
words
suitcase
against me,
video to
George.
me.
Yes, yes,
All
means
because that's
all.
what they're saying. They won't be specific
suitcase
because they don't
video
know what they're
is
talking about.
listed in one of the things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980.
Here's
I
the
don't know what that
problem.
is.
The defense doesn't either.
I'm just looking at the words on the paper.
Okay, here's
How
the
does it
problem.
need to be done, Judge?
They can't argue
Well,
it because they don't know
what
what
the
it
state
is.
is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court?
Foundation is when
evidence
you
being
present
omitted.
They
evidence,
conceded they
not
need to lay the
in
appropriate
pre-trial.
foundation.
Well,
Part of their argument.
okay,
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
Mhm.
and I have
And
no
he
problem
doesn't
with
have to
that.
do it till
I have no
trial.
problem with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
You objected to everything. What are you
Okay,
talking about?
that's what this sounds like
That's
to
what
me.
the judge
It
just
sounds
said.
like this is a situation, well, Mr. Henderson, you didn't object to this on the state's
Oh, so therefore I object to everything
list
just in case
of
I want
exhibits.
to
You
later.
did not object to it. You can't object to it now. I don't think
Okay,
that's
I'm
fundamentally
done.
correct.
Okay. Oh my. Oh my. Oh my. Oh my.
So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I
Judge
would like,
Kraynick
because
is so over this.
I know it's
He
a
is
different
so over
jurisdiction.
this.
People do things differently, okay?
That is not a face I
30
ever want
years,
to see on a judge.
I've never had to do this in a
Wow.
criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last minute issues. Then y'all parachuted in on August the 30th.
Yes.
And you
There was
knew
no
what you were
order,
getting
there was no
into.
request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason
problem,
behind that
sir.
was because Ms. Boone at that time was representing herself pro se. And to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As the foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation.
And
if
that
they're able
happened
to
to
do that,
trial.
I'm not foreclosing you for making objections, but as of this point in time, your
It's coming
objections are
in.
preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling, that doesn't waive my right to object to something as they're trying to admit it,
That's what he
based on
just said.
relevancy,
But he's letting it all
foundation,
come
or
in.
any of those
You can
things,
try to object,
then
but he's letting it in.
I don't have a problem with that.
Then what are you
My
talking
concern
about?
was the way this looked like to me, if I didn't make an objection to it at this
Dude,
time
you
for this,
stop.
I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
We're just, I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day.
Oh my.
This is how Cellbrite works. This is my educational background, blobbity blobbity with this software. And I pulled this extraction out.
DA
Mr. J
Cacciatore
sent
looks
me
like
this
he would rather
carve
be
out of
anywhere
this
else than here
extraction
right now.
before trial. In fact, she picked it up yesterday. And I believe, you know, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this
That's the
line
problem.
of text
The
isn't
defense
okay.
can't be
This particular
specific because they
photograph's not
don't
okay
know.
for this reason. That's what we were hoping.
Because they are
Okay.
unprepared.
Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing.
Sure you
What
did.
we did not, or what we failed to do because of the time restraint for the ones that we didn't list the number and I didn't give detail as to like IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant, at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
They're not saying that, dude. They're saying you have to
Okay.
keep your objections within
I'm
relevancy.
going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary, but based on the state's proffer, I'm going to find that the
That you're being
different categories
you're
of
trying to
documents that
do
he's identified as
shenanigans.
reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation and based on counsel's proffer, seems like they might be able to do so.
AKA go back to the drawing board, Defense. It's
Any
coming
questions,
in.
sir?
Now, I just want to add something for the record.
Yes, sir.
The state doing its proffer said there were no photos of the child. That's not correct. There are photos of the child.
No, he said there were lots of photos
That are being
of the
sought into
child.
evidence.
Yes, Your Honor.
State? Response, if any?
Exactly, Jester. Mhm. If you reviewed everything, then why can't you be specific about what you're objecting to? Mhm. And now all of a sudden you're going to talk about pictures of the child? Mhm. The point was there are no pictures of abuse. Mhm. Gee, I wonder if they're going to submit that picture of Lucas in the actual suitcase sometime before that Sarah took the picture of with Brian actually in it before a vacation, or rather in that there was some issue there about that not being a safe thing. Is that the picture? Mm. Yeah, Juju, for the record, right? Like what the judge is saying is that there's no foundation or relevancy objection that's going to be sustained based on what he just heard that the evidence was. And
I
because
don't
the
believe so in
defense
either
can
of the
be non-specific.
folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
He doesn't see any pictures of the child in there. I think that maybe the defense is looking at an old submission and they're just not up to speed. I think the defense just proved again that they're not on their game. We all need to throw some prayers out there for George Kraynick for this one. You know how you normally don't talk during these proceedings, but this defense has just got me over the edge. I'm going to have to do better and mute more often. Sarah's demeanor has changed a little bit, and I don't blame her. This is not going well. This part for the defense. They won their other motions, though. They are going to be able to try to present the overt act in testimony at trial and then decide on BSS at trial. They did win there. What do you think the judge is going to do, guys? You know, right now he's going through, and if he doesn't find a picture of that child, how do you think he's going to be looking at the defense right now? Like, excuse me, did you just say that they did something they didn't do? Owens, look at that posture. Ooh. He's going to allow it all in. And he's going to call Bull Dinky on the picture of the child unless he finds one. Yep.
Okay, I see two images. I couldn't recognize it as reflection of children in I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I
Wow.
haven't seen the picture, so I'm at a loss.
Well,
A
it's
sorry, Judge.
reflection.
extraordinary file name, but I'm going to remove those two
Okay.
exhibits that they're
I
talking
take care of that issue for you,
That,
sir.
that takes care of that issue, Judge.
Okay.
But the point that I'm trying to
Yeah,
make
was it a
with
snow
that
globe?
and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now?
Mm-hmm.
They can make a proffer. I understand they can make a proffer, but they're proffering evidence. Once it goes up, the witnesses and all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
All right, thank you very much.
Yes.
Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel? All right, is that acceptable to the defense? Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
Okay. All right. So looks like we're coming back tomorrow. That's it. That's it. We don't have an answer on this part of it, but we had plenty on the others. That was interesting. I do want you to see Sarah though. Let me add her back. Until they ended out. There is no sound, but it is we might as well get the visual of what's going on. ADAJ looks annoyed. DA Cacciatore looked like he wanted to be anywhere else. I did see Judge Kraynick trying to hold his composure a few times. They do seem very annoyed. Sarah's attorneys are not sitting like right next to her. Like I guess they cannot, once the prison guards decide that they're going to like get her ready for transfer. They do need to take her out in shackles and everything during the lunch break. And she was just pointing at Henderson saying she wanted to talk to him, but he's leaving anyway. He's going to lunch. Yeah. But I don't know. All I can say is there's going to be a lot of fireworks. There's going to be a lot of fireworks in this trial. It does seem that the defense and the prosecution are both very adamant about their positions, and they are not having a lot of tolerance for each other right now. I think mom's going to show up. Judge Kraynick is going to come in and say, like, y'all play nice or you're out, kind of thing. Kind of like the one in the Kohlberger trial that said, hey, we expect you all to act like adults, I would imagine the gods that have to deal with Sarah on a daily basis are not amused in general. Okay, I think that's it for this. I think I can remove this now. Um, and go back to my little circle. And yeah, well, thanks for keeping me company. I'm sorry if I annoyed any of you with my extra commentary. I could not contain myself today. I will do better tomorrow and try to keep it in. But ooh, they were just really blowing my mind today with their lack of preparation at this stage of the game. Uh, to have a that lack of presentation, preparedness in such an important case that you volunteered. Oh, thank you, Couch. He says, oh, by the way, the bingo card is updated. I will make sure I post the link tomorrow. Uh, that would be the true crime and legal update, or is it a trial one? I forget. Is there a special link there, Couch? Like, if you could post it for me, I'll make sure I copy it. But anyway, um, if it's just a regular link, just tell me. Oh, you did? I couldn't help it though. I'm usually much quieter, Charlotte. I usually don't say anything, but I was getting a little overwhelmed. It was bubbling out of me, for sure. You know. Well, anyway, I'm going to schedule again for tomorrow, and we'll see. If it's live, we'll go live. If it's not going to be live, we're not going live. Okay, I'll be here to talk to you for a little bit, but once we know whether it's going live or not, it'll be out. If there's any change, I will post it on the community tab. I'll try to keep you informed. Well, thank you so much for joining me for this hearing. I'm very excited for this trial now, even more than before. Although a bit frustrated at some of the stuff going on. I mean, I'm not a lawyer, like, so I really don't have any, you know, real stake in the game, but some of it just really, I just don't understand how they can just, oh no, how they could just be so unprepared, you know. And gosh, I wonder what lunch is going to be like. If those lawyers go anywhere near Sarah Boone during lunch, I think they'll be sorry. I think they're all taking lunch somewhere else right now. I really do. Well, anyway, and defense is going to drive me crazy with their shit. Exactly. It's, you know what, and I kind of feel for Sarah Boone because she does deserve a good defense and a good shot in a fair trial. In they're just bumbling, but it's kind of her own fault if she's going to be taking direction so much. They're just taking a back seats and stuff, not doing lawyerly things because, you know, Sarah wants the attention and people to just do what she says. She doesn't exactly want their expertise, does she? And so, therefore, it's not coming forward. But it is what's necessary in the courtroom. And man, oh man, mm, it is pretty obviously done. Like Charlotte, some of it, like to actually say that we object to everything, but not saying what the objection is was full-hearted, full-heartedly, like an offensive to the judge. Actually, how many times did he said, "But what is your specific objection?" You cannot object to everything, point blank. Well, I'm just, and what did he say? Like in a nutshell, uh, Attorney Henderson said, "Well, I'm objecting to everything to preserve my right to object to anything." Which is a given right in trial anyway. Like, what are you talking about, dude? You don't object to everything ahead of time. Like, no, dude. Like, mm, anyway, I thought that was funny. It's kind of like when Owen snuck in those motions in the behind a motion without writing a motion, that he was going to try to suppress some other things. He got called out by the state, and the judge said, like, what's that? You have until midnight to file your motion legitimately. And he was like, well, I was just preserving it like that it came up so that I could file the motion later. The judge is like, that's not how we do things. Like, that is not how you do things. So basically, in the future, in Florida versus Sarah Boone, we shall see the defense team of James Owen and Carl Henderson try to rewrite standard law and forget all of their teachings in law school and just redo it their way because, Hey, that's the American way. Okay, there's enough snark from me for today. I'm out. I'll be back in the morning. I just cannot anymore with this. She is still trying to defend herself, Anna, and I don't blame her. She feels like she needs to take control after seeing those two in court. Like maybe she was actually hoping she stayed pro se. I don't know. She should have asked for a lawyer at Miranda. Yes, exactly. I almost believe I almost believe Sarah does not comprehend what is at stake here. You know what? I don't think she has a good clue on what's actually going on. I think she's got some rose-colored glasses on, Juju. I do think I have been worried about that at least recently. An amount of delusion that could be at play here, actually. Yeah. Yep, exactly. I worry she might be somewhat delusional. I'm a bit behind. Are you guys saying that Boone tried to take the podium? No, not yet. But she is going to take the stand in this trial. She has to, or they cannot present the battered spouse or syndrome defense. The first step of it will be Sarah taking the stand in actually having to testify to the overt act that made her feel imminent threat or triggered her to the mindset of BSS to where she overreacted to a situation in a way to be able to use it as self-defense where there was no real threat. An average person would not see the threat, but someone with BSS would feel imminent threat based on past situations. Okay. She has to actually testify as to those past situations, her feeling, and the overt act that triggered her, or none of it comes in. None of George's history, none of it, none of the prior arrests, none of it. Okay. And if it doesn't come in because there's not a satisfactory overt act, the jury is going to be left wondering how do we prove that she has this? Is it just enough for her to say it? Because not even the testimony of expert witnesses will come in for BSS if there is no overt act. And yep, she's trying to be the puppet master. I agree. You know what, Anna? Her testimony is going to be riveting. We already know it's going to be changed from what her story was before. Or she did testify completely differently in a motion to suppress hearing. And also that we do know that the state has already proctored that they will be putting that into evidence. They added it to discovery and they said, well, you said it and now we're going to use it. Yep. So there we're at. All right, guys. And we'll see you all tomorrow, hopefully. And if not, Friday for opening statements. Like, we're on track. We're on track. You know? So, thanks for joining me. I really love it when you guys are here. Okay. I'll see you tomorrow. Have a good one.